Hi, good morning. Welcome to today's webinar. I welcome you all from RA UK family, and we have been doing the programs on knowing our Rajasthan talents like artist, poet, singer, and in fact, knowing the sports personality and many more. We have done the program on yoga, meditation, and I remember we did a program on government financials and schemes, and that was quite one of the popular program. As you are aware that COVID-19 has changed a lot of dynamics, like having virtual meeting. People are more careful about health insurance, and to cover themselves during any casualty. So today's webinar is on the similar topic. It is very, very important and at times not much thought about. And that is what is will, lasting power of attorney, and how to create a trust. So we have a guest who has a lot of experience in creating will, trust, and lasting power of attorney. But this is a kind of a gray area, and let's try to understand a bit more about these from our guest for today, Mr. Jaswinder Singh Ahuja. So I would like to invite Jaswinder Singh Ahuja today for this show.
Thank you very much, Naresh Bhaiya. Could you hear me okay?
Yes, definitely. Yeah, it's
Right.
loud and clear.
Perfect. So very good morning to everybody attending or whoever is going to listen to this later on as well. So Naresh Bhaiya, thank you for the kind introduction. My name is Jaswinder Singh Ahuja, and everybody calls me Jazz here. That's the first thing when you come to Heathrow, your name gets chopped in half.
Yeah.
So please feel free to call me Jazz.
Yes.
I'll
Thank
just
you, Jay. Yeah.
Thank you, Bia. A little bit of introduction about us. So we are FCA, Financial Conduct Authority, authorized and regulated financial advisors. We're fully independent. So it means we are working with the clients to give whole of the market advice. We're not selling any particular company's products. So we are full consultants for the clients. And I personally look after investments, pensions, and inheritance tax planning, and wills being very important part of inheritance tax planning and how you want to pass on your assets to the next generation, etc. So we will cover that in today's webinar. Please feel free if you have any questions about the content I'm going to discuss today, or if you have any questions about other areas, because I've got my colleagues online listening to this webinar who are experts in mortgages, life insurance, private medical cover, etc. So we cover the full spectrum. We know Naresh Bhaiya very well, and that's the reason. Thank you very much for the opportunity and come and give this education piece to all our family.
Yeah, in fact, I remember attending your seminar, and that was around, I think, like 2 weeks before.
Yeah.
And then I found that I was struggling in terms of understanding what the trust is, what the will is, how to create that. Because my perception is like once you create a will in UK, it will also be applicable in India. But you have cleared many of those doubts, so which was very nice to have. And then I discussed within a group, and we decided we have one session for Rajasthan Association United Kingdom for our family and friends. So I'll not take much of your time, and I give the handover to you, Jaswinder Paji Jess. So
Thank
yes.
you very much, Naresh Bhaiya. So absolutely perfect. I will cover that point as well. You are absolutely spot on. In reality, UK will should cover Europe or anywhere else in the world, where your properties, your assets are. But practically, having come from India myself, as you know, I'm from Delhi, so I realize practically it doesn't work what we see here. Going to India House in Holborn, that's painful. Getting things attested here and getting notary public to understand that this is a valid will from the UK, it's hard work. And that's why, to keep things simple, having a UK will should cover UK assets. Everybody will recognize that quite comfortably, but also having a will back home, it's added protection. UK now going through Brexit, as you know, 31st is not far. At the moment, UK will cover property in the Europe as well, except Scandinavian nations. But what's going to happen after Brexit? Are we going to have a soft Brexit, some last minute deal struck? So these things are constantly evolving. And will is exactly the same. Will is very moving document, and that's why you put anything on the will, how you want to distribute your estate according to today's wishes. But by the time kids get to maturity, 18, 21, 25, kids are getting married, you know the financial circumstances better, you know where you want to be domiciled, whether you want to be here for the rest of life, or there is family, there are elders back home, you want to be domiciled back home in India. So all these things need
Yeah.
to reflect in the will as well. So we can make any changes. As you know, all these minor changes don't even cost anything. So we can keep making changes and amend the wills as it goes. As the life progresses, we need to make sure the will reflects current circumstances.
Yes. Yes.
Okay, shall
So
we go through the quick slides as well? We can email this slide presentation to everybody in the family. So Naresh Bhaiya and Alok Bhaiya, please feel free to share this with everybody. It's all absolutely fine.
perfectly. Yes, we'll definitely share that with all our family and friends.
Thank
So,
you.
Alokji, you may start the presentation from the slides. Yeah.
Great. Thank you very much, Alok Bhaiya. Right. So I have got this presentation in front of me, and I will go through the slides just to give you a flavor of what we're going to cover today. But as I requested earlier as well, please make it interactive. Any questions you have today or later on, please don't hesitate to contact us. So this question is very common, that why do I need a will? And sometimes when people are starting the journey and building their assets, this is very common thing, that why do I need a will? I don't own much, at the moment. I don't have property, I'm renting, etc. So these questions are quite common to us. And in all reality, will is absolutely essential. So I don't see any drawback or any loopholes where you can say that, having a will, there are side effects to it. Not really. So keeping a will and keeping it simple and clarified, that just avoids all the hassle that potentially could happen to all the family members left behind. So what is a will? Will is just a plain document which tells somebody else reading, after the death, this is how I want to distribute my asset. And let me give you some examples as well, and feel free to ask anything particular to your circumstances so we can cover that as well. So if we're talking about, say, a couple, husband and wife with a family of kids, and husband could say that, why do I need a will? Everything is owned jointly. But still, there are rules. If somebody dies without a will, that is called dying intestate. And this process or this phenomenon of intestacy is quite bad. In the UK, it's not that straightforward. Getting the will done, and then you can expect your assets to be distributed by the right people, who you call executors. So executors are the people who are going to carry on your wishes after the death. It could be spouse, it could be husband, wife, it could be children if they are over 18 years of age, it could be your trusted friends, accountants, etc. Whoever you can trust, they can be your executors. But you don't need to go to professionals in reality, accountants, solicitors, or us. There is no need to have anybody else as your executors, because keep it simple. If we're talking about this family and kids are over 18, then husband can say that my executors are in my will is my wife and my children, and vice versa. For Mrs., she could say that, my husband and my kids are the executors of my estate. So they will distribute the assets according to the proportion I have nominated in my will. And the next thing comes who the people are related to this will. You will see in the following slides as well. Donor is the person who is giving the will, and beneficiaries, as the name suggests, are the people who are expecting to receive all this. So in husband's case, wife and the kids are potential beneficiaries. So husband is saying everything from me goes to my wife 100%, and then to say two children 50-50 each. So keeping it documented just avoids all the technical problems, all the financial issues, going through financial and legal teams. If you have got a will in place, then it goes through probate. Anybody who dies with £5,000 plus estate needs a probate. So it's pretty much everyone will need a probate. But if you don't have a will, then it goes through administration, where government and the legal system is appointing people who are going to come into this and then decide who the best people are for benefits according to your wishes. But because your wishes are not documented, interpretations and then subjectivity comes in. For example, if people are not married or civil partners and they're living as partners, but without a will, it doesn't benefit them the way you want to. And will can be put together by yourself only. Yes, we go into compliance mode. We have to go through all the details with our legal teams to make sure everything we recommend you is indemnified and guaranteed. But in reality, you can do a will online. You can go to WH Smith, buy a pack, and do a will yourself. There are a lot of charities where they suggest that you do a will through them, and you can leave a part of your estate to them in your will, and that's why they're encouraging you to do the will through them for free. So as long as you have a proper valid will, it doesn't matter where you've got the will from. And after doing this will, you just put your wishes, you sign, you date, and then you need two valid witnesses. And just make sure these two witnesses are not the beneficiaries. So for example, if Mr. is doing will, beneficiaries are Mrs. and two kids. So make sure these people are not witnessing your will. So it could be next door neighbor, it could be us, even doing online nowadays, with COVID situation. So it's all there. So let's just go on to the next slides, and you can see on the screen how it needs to be done. So a simple will is just putting your documentation, what you want, who the executor will be. If you have minor kids, then you need guardians as well. If kids are minor, then you need guardians, and guardians and executors could be same people. We recommend you having two guardians and executors, but you can get away even with one. And put your friends or people you know in the UK as your guardian or executors. That is better. But if you don't want to, or you feel they're not the right people, for executing my wishes, then you can even have somebody from India as your executor, as your guardian, as your power of attorney, which we can discuss a bit later. So it's all okay. We prefer having somebody in the UK who can physically carry this on your behalf. Otherwise, yes, people can fly from India and get this sorted here. But if in the current scenario of COVID situation, it could be problematic for anybody to commute, or somebody not having a valid visa and not be able to transit, that can create physical problems. And that's why it's better to have somebody in the UK in your will as your executor and guardian, and to keep things much comfortable for future. Single will means husband is passing on estate to other people. It could be wife, it could be children, it could be brother, sister, parents back home, nephews, nieces, etc. So when we talk about one person doing a will, it's a single will. But when we say mirror wills, it means husband and wife, their wills look very much similar. So it means husband will say, I give everything in my will to my wife, 100%. And then after the second death, if my wife was to die before me, then it goes to two children or three children in equal proportion, etc. Okay, so that is called a mirror will. It's economical as well to get mirror wills done. But if you have different wishes, so for example, husband is saying that everything goes to my wife, but if my wife unfortunately predeceased me, then I want my assets to go to my brother, sister as well, not just my children, my parents as well. Then Mrs. could have different instructions for her will. She could say, I want my sister to benefit because she relies on me, and I want other people, my godchildren, to have some benefit from my will and my estate. So you can have different wishes. It doesn't need to be mirror wills, and we will guide you, we will advise you, and there's plenty of guidance about all these subjects. So just shout about what you want to know, and we will be able to accommodate everything in legal documentation. This trust bit, Naresh Bhaiya highlighted as well. It is quite common perception that trusts are scary, but in reality, trust is very simple documentation. Like you have a partnership and partnership deed, like you have limited company with memorandums and memorandum of association, memorandum of articles of association, etc. Same thing happens to trust as well. Trust has a trust deed, which is the guiding area, how this trust is structured, etc. And why this is done? It is done for specific reasons, and there are a variety of trusts. But to keep it very simple for today's presentation, there are two types of trust. One is a will trust, which is just in the will. It doesn't require any extra money or fancy terminology. It's simple will. When somebody dies, then the will is instructed to do something. So let me give you an example. It will clarify things better. So for example, same scenario which I mentioned earlier, husband and wife and two children. Husband could say that now I'm 75, 80, 85, and why would I give everything to my spouse, my wife? And because if she dies as well, we die together, or she dies very quickly after my death, then my kids will have inheritance tax problem if our estate is jointly over 650,000. As you know, the nil rate band is 325,000 pounds each. So a person can pass on up to 325,000 pounds without paying any inheritance tax. And between spouses, husband and wife, there is no inheritance tax to worry about. It's only after the second death where you need to be concerned about it. Or if husband and wife are passing on things not to their spouses, not to their husband and wife, but to children directly, then make sure you don't pass more than 325,000 pounds. Otherwise, they could have immediate 20% inheritance tax liability, potential liability. And otherwise, anything over 325 is taxed at 40%. So it's a huge thing. There are other benefits as well, like you can have 325,000 pounds, which is called nil rate ban or zero tax. And you have another 175,000 pounds each, which means one person can pass up to 500,000 each, provided they're leaving their main residence as part of the equation, and it's going to direct blood relations, direct descendants, children, etc. And that's why between a couple, you can have up to £1 million without inheritance tax problem. So that's what I'm suggesting. Keep your will, look at the estate value, and then we can decide and guide you what's the best way to do it. Whether you need to set up a trust, or you can say, after my death, I want 325,000 pounds worth of assets to go to my children or grandchildren directly. So there is no inheritance tax to worry about after the second death. So there are many ways we can overcome all these objections, issues. So what you see on the screen here, Protected Property Trust, as the name suggests, it just protects, the assets within that trust. If you have any disability in the family, any special needs children, elderly, then you can have a trust for them as well. So you don't need to directly nominate them as your beneficiary, but you can create a trust. So let me give you an example. Say husband and wife with 3 children, and one has some special needs. And we have autistic child at home, our son Ronak. So that's why we understand this, and it's very close to our home. So if there is any disability or special needs in the family, then you can put your child as the beneficiary under a trust. It means they're not receiving the money directly. The trust is looking after the expenses and the future growth and the income for everyone. So it's comfortable with that situation. And any means tested benefits, for example, if these kids are being paid anything from the government or council, they can still receive all that. And because you've left money to them, they don't lose their means tested benefit. And that's how you can protect your loved ones in this scenario. And there are other issues as well. As you know, divorce rate is quite bad, and we've been very proud of our culture and values that, divorces were frowned upon. But unfortunately, now with the children, being raised in Western market and in these European nations, and even back home in India, it's becoming very prominent. So tolerance is not there. People are going through divorces quite a lot. If you're concerned about your children potentially not finding the right partners, right husband and wife, and you want to protect your assets, then a will properly done can protect that situation. So God forbid, if anybody goes through divorces, then you won't lose your estate to son-in-laws or daughter-in-laws claiming. So you can keep the money in your blood relations. So your money goes to your children directly and their children. So their spouses or their ex-spouses cannot take your assets with them when they divorce. But I'll give you one more example on this topic. So say kids getting married, say our daughter gets married to somebody else, that boy, what happens that after some divorce issue or if death happens and our child is not there, but their spouse can remarry and take all the estate with them, and then grandchildren are not left with anything from grandparents the way you intended. And in order to avoid all that, you can just keep all this in blood relations. You can keep everything in bloodline planning, which is a very simple clause we put in the will called pars terpes. It's a Latin terminology, but it's just simply means everything stays in your bloodline and nobody else can take your estate away from yourselves and your loved ones. I'll give you one more example. Now, companies and kids coming into businesses, if you have put things in a trust, it also means if business or anything goes bankrupt, then trust assets are protected. If you have 10 properties, buy to let businesses, you can ring fence them, put them in a trust. So if any insolvency issues come to you, your spouse, your children, then the trust assets are protected. Nobody, no administration will come into that to dissolve that trust and pay up. No, because everything in trust is like a limited company. It's completely separate entity from yourselves, your children. So if your children get into any wrong business idea and in future they claim bankruptcy, insolvency, or creditors are claiming the money, the trust assets are protected. So divorces, protecting against creditors. So these are very important and effective ways what you can achieve through a proper will or setting up a trust. So one trust is simply in the will which comes into existence after the death, called will trust. But the other form of trust could be a lifelong, life-standing trust, even you can set up now. It means that all my properties will pay an income to my children and for their education, for their medical, but my kids are not allowed to sell these properties and buy expensive cars or blow this money on something you don't want that to happen. Okay, so you can protect your estate and your wishes with the trust work, with effective and correct up-to-date wills. So that's what it is. You keep everything with flexibility. You can even say, like you see flexible lifetime in trust on the screen, that if husband dies, then wife has every right to live in that property forever. She can even downsize, she can sell the property and move on. But the beneficiaries are children. It means the council will not come in and ask for the money for the care. Potentially people are living much, much longer in care homes or needing care at home. And that's why with Alzheimer's, dementia, or any other disability, you can avoid all that by having these lifetime interest trust and asset protection trust. It protects whatever you put into that and passing on to your beneficiaries according to the trust deed. So these are the ways you can protect. You can have a life standing trust, which you can set up now if you have built up your estate. Otherwise, you can put a will trust in place. It means that trust will be effective after the death. And that can say half of my property goes directly to my children. So it is more efficient for inheritance tax. Okay. So feel free to type in any questions or we can pick it up later. You will see our contact details later. Alok Bhaiya, could we go to next slide, please? Thank you very much. So let me cover this point as well. Will is normally open after the death. So once somebody dies, you want to know how their will was done. And that's why will document comes out and everybody looks at it. Sometimes it's a shock to the family because they are expecting the money in different proportions. So you can even take out any family member you don't want to benefit. Let me just touch on this topic quickly before we go deeper into lasting power of attorney. So if you want to exclude somebody not having anything from your estate, so for example, a couple with 4 children, and you want to say, I want everything to go to 3 children as 1/3 each, nothing to go to the 4th child. You can do that. You can completely take somebody out of your will. You can do that with your spouse as well. So it's according to your wishes. Will is individual. You can't have joint wills. And just like pensions, it's an individual document. And if you're doing a will for yourself, you can say who you want to benefit. That's very simple. You don't need to discuss that with your spouse and children. If we are putting this document together for them, we are not going to share any details from anybody else. It's only between you and us. If somebody is doing even the witnessing, your next door neighbor comes, they are just witnessing that you are signing in front of them your will. They don't need to know what you put in your will. Okay, so keep it very simple, and you're not obliged to share the details of your will with anybody before your death. If you want to, you're more than welcome. Normally in our families, people know, what to expect from the will. So there is no problem later on, but it's entirely up to you according to your family circumstances. But let me go back to my example. If you're excluding somebody, that 4th child from your will, there are many court cases that you can read about. If you exclude a child and it's not done properly, that 4th child will challenge this will after the death. After your death, it is challenged by your child or their spouse or their children, and potentially they have been winning the cases because they've not been done properly. But why people have been challenging the wills? Wills are challenged normally on 2 grounds. If somebody has done a will under duress or somebody has pressurized them to do a will in this way. For example, if a child lives abroad and all the siblings here are saying, we want everything from parents' estate, 1/3 each, take the 4th child out, then, it's putting pressure on the parents to do the will this way. So if it is proven that will was done under duress or under pressure, then obviously 4th child will get their share. And secondly, the challenge could be that, by the time this will was done, my parents didn't even have mental capacity. So these are the 2 main grounds where the wills are challenged. So how you can do that? If you're excluding somebody from your will, just put their name and details in the will as well. So when we draft a will, before even going to compliance team, we draft a will and say, these are my 4 children, and this is my 4th child, and I'm putting a deliberate exclusion that deliberately I'm excluding this child from the will. So everybody knows it's not an error of omission, that, it's not that father had dementia, Alzheimer, and that's why they didn't remember they have 4 children rather than 3. No, I'm documenting all 4 children in the document, but then I'm excluding 4th child from that will, so it's clear. So nobody can challenge in that way. Obviously, they're bound to challenge, or they can challenge, but they should not win that case in the court. And we also attach a document called expression of wishes, which is not in the will, but it stays next to the will in the same possibly envelope. And it says that this is the reason and rationale why I've taken my 4th child out of my will. So it could be a father is writing that, my child, I haven't seen them for last 20 years, ever since they got married. I don't know where they live. They don't look after me. They're not worried about me in this elderly age. I don't know how many grandchildren I've got. And that's why I don't want to go any money from my hard-earned estate to that child. If they're not bothered about their parents, I just want to take them out. So if that's the case, you can exclude them in the right manner. So when judge looks at that contest later on, they will say to the 4th child, don't try your luck. Your father or mother have clarified the reason why they've excluded you from the will. So that's why we know the experience in the market and how these things need to be structured. And even when you put this document together online and do it yourself, just have 2 valid witnesses who are not your beneficiaries, and then make sure if you're excluding someone or even changing the proportion, you're not giving everything 25% each to all 4 children. You want a different proportion. You can justify that by having expression of wishes document that, 3 children are very well established. 3 children are doctors, dentists, listers. I'm not worried about them. But 4th child hasn't got a well-established business or job, and I want to support them more, because they need my help and support. So you can do all that, and as long as it's properly justified and documented, then there is no contest later on or hassle, and that will also ensure that all 4 children have relationship forever after the death as well. Otherwise, if you don't do a proper will and it's open to interpretation and they have fights and quarrels after the death, then they will lose the relationship as well, and you don't want that. So keep everything documented, and that will make sure they have a relationship as well forever. Okay, so coming back to lasting power of attorney. So previously they used to be called enduring power of attorney, EPA. Now they're called lasting power of attorney because they're much more detailed now. And lasting simply means they last even after somebody has lost mental capacity. In reality, they are most useful when somebody has lost mental capacity. So there are 2 types. One is called health and welfare, and one is called property and finance. So as the names suggest, property and finance will take care of your property portfolio and anything you have in your pension, bank accounts, investment portfolio, ISAs, etc. So property and finance will say, if I'm not physically or mentally capable to manage my affairs, then I'm giving this power of attorney to my wife and my children, or only to my wife at the moment, so she can run all my affairs whilst I'm still alive, but according to my wishes. Okay, so lasting power of attorney is irrelevant after death. So it is only valid and relevant whilst the person is still alive, but possibly they don't have physical and mental capacity to act or sign. For example, if it's a joint property you own and you want to sell, but the second person is not in the country, so you can't sell it. But if you have given power of attorney, then you can sell this, and it is not problematic. It's not like a Bollywood movie when somebody can take your estate away or take your business away. No, it's a very well clearly documented power of attorney, and it is also registered with a legal body, let's say with the Office of the Public Guardian. So it is correctly registered, so nobody can have a fiddle with that. And if somebody feels it's been misused, there is a whistleblowing procedure as well. You can clearly call Office of the Public Guardian and they will take action promptly. Okay, so property and finance, you don't just need it after loss of mental capacity if you're not present in the country. Or, for example, in our household, we did our wills and power of attorney 6, 7 years ago. And the reason was my wife doesn't want to know anything about finances, nothing to do with pensions, how much money we have in investment ISA, what is the return we're getting. Now, this year, we've had the best year in stock market history. But sometimes spouses don't want to know. Your children are not looking to know financial markets. And that's why, even for that reason, I can operate my wife's pension or my wife's investment ISA on her behalf because I have got a power of attorney from her. So it doesn't need to be that you activate. So you have the choice. So health and welfare, you don't have a choice because you can't switch off somebody's life support machine. So health and welfare covers how you want to be looked after in future. So you're giving that responsibility to your wife and children or husband and children that if I'm not able to manage my affairs, then they will be the best people to make a decision whether I should be in the coma for 6 months or 1 year, or whether I don't want to die as a cabbage. Some people say like that. And that's why I want you to switch off the life support machine and let me go peacefully if that's the situation. So you're giving power of attorney, whether you want to stay in a care home or whether you want carers to come at home to look after you. So all that can be done according to health and welfare power of attorney, and property and finance will establish how your assets are dealt with. So with property and finance, you also get an option whether you activate it straight away. So your husband or wife can operate directly now. You don't need to register. For example, we haven't registered a power of attorney with the banks. But if I take that power of attorney for my wife into the bank, they will take my passport, driving license, establish my identity, and they will take my instructions about the bank accounts after that. So we don't need to take it to the bank or investment or pension providers or sell a property like that. So everybody can operate as normal. And you can say, I don't want to activate my property and finance lasting power of attorney straight away. It only activated after loss of mental capacity. So you can do that. And health and welfare, it is only activated after loss of mental capacity. So both these documents are very important because with demographics and statistics, you can see people are living much, much longer. The statistics and average life expectancy could be 85 years for male, 88 years for female, which is constantly changing according to the Office of National Statistics. But it's not about that. I've got clients who are over 90, over 100, and every time you meet them, you realize that, their age doesn't reflect, how they physically and mentally are. And you end up checking the passport. Are you really that old, Because nowadays, it's just a number. People are living much more, savvy, financially very astute, in such a long and old age. So having these documents, just make sure everything can be done according to your wishes. I'll also give you one more example about lasting power of attorney, where you can say, I want my wife to be my power of attorney activated straight away. Mrs. could say, I want my husband to be my power of attorney straight away. And then you can say, I want my child or 2 children or 3 children as the replacement attorney or substitute. It means they're not my attorney today, but if anything happens to my spouse, then they can come in and manage, and you don't need to draft these documents ever again. So you can make it future proof as well. So it's all clear and everybody knows where they stand. And if you want to see your children, how they turn out in future after marriage, how they're working, their business, and whether they're living here or they move abroad. So if you have few unknown variables in the equation, then you don't need to make them power of attorney today. You can say, husband and wife are power of attorney for each other, and kids are replacement attorney just in case they are needed in future. And you can even put your trusted friends as power of attorney, because if you know my friend is very financially savvy, he understands how to operate finances, manage investments, or he's got legal background, they'll be fine to manage our family affairs. So you can appoint anybody you can trust, and you just need to tell them, because they will be receiving documents to confirm that, and that's all. So wills and power of attorney will take care of that. And I will just cover one question which is coming quite regularly, that we don't have anything we own. But even if you have a life insurance being paid, if you don't put that in a trust, that anything the life insurance paid could lose 40%, uh, potentially going to taxman, just because it's not done properly. So look into your assets, look into your estate, and make sure if you have done proper life cover, it is set up in a trust. It doesn't cost anything. It's just one-page administration that you could do yourself from the website of the life insurance company you have, Legal and General, Scottish Widows, Zurich, Vitality, Prudential, any company you have, they all have this. So just look into your financials, because like health, financials are looked at, everybody has New Year resolution to look at it. So it's a good timing from that perspective as well. But look into this and get everything up straight, so you're not leaving everything to chance. Because if you don't have a valid will, anybody could come, your nephews, your siblings, your friends, that you promised them this money, and anybody could come out of the woodwork and claim out of your estate. So to avoid all that, just have a proper will and keep it updated. That's all I want to say about wills and trust. And last point I can see on the screen, it's about intestacy. So if husband and wife have a joint property, then it goes directly after death. So it's a joint property, husband passes away, in this example, wife gets it straight away. So that's fine. But anything over and above that, potentially only £270,000 will go to your children or spouse. So only 270,000 out after the property, etc., goes to your spouse or children, how you want to do it. So, and then let's give you an example. It'll keep it simple. So say your estate is 1,070,000 and properties are not part of that, then only 270,000 will be going to your spouse if you don't have a valid will in place. Okay, so 270 gone, then 800 grand is still left. Then 800 is divided in two halves, 400 grand each, and your spouse will get 400,000 more, one other half. But one half, 400,000, goes to your children. But if your children are minor, then that is put in a trust which nobody can access before 18. And kids can't even say that we want this money to go to our mother, because they are not over 18 to make that decision. So it can create a lot of hassle. And to keep it problem free, just put your documentation in place and just write how you want to pass on your assets to your wife, your children, your brother, sister, etc. And if you don't have a will, you can see the chart in front of you. It goes to your spouse first, a proportion, then to your children, and then to your father, mother, brother, sister, grandparents, uncle, auntie, and ultimately the crown. It goes to the queen if you don't have these layers of protection. So it's a simple algorithm you have to follow, and make sure you cover every eventuality. You need to cover, if God forbid, husband and wife were to die together, what happens at that stage? So you have to cover all these eventualities. What happens if the kids are minor and husband and wife were to die here, and you want your children to go to their grandparents in India? If your kids are British citizens, there is every possibility that the government won't allow them to go back to India. But if you put guardians in place, if you write that in your will, then they have to respect your wishes. Otherwise, you're looking at worst case scenario, foster care, these kids being adopted by foster parents. So just do these documents and it will make sure everything is according to your wishes. And honestly, I can't emphasize enough, how important these documents are. Yes, your investments, pensions, growth, mortgages, property portfolio, protection, they are equally important. But having these documents are not a substitute, they are equally essential. So please have a look and please let me know if you have any questions. Otherwise, we can go to the next slide, please.
Yeah, there was a question coming from, there were a lot of questions coming, and one of the question is from Mirta Baisa,
Sure.
and she is asking like, can grown-up children make will for their parents as well?
Okay, so thank you very much for the question. But grown-up children can ask their parents to have a will in place, but parents have to decide how they want to do the will. And if parents are comfortable having these grown-up children sit next to them whilst this will is being done, that is okay. For example, if I was doing a will for grandparents or parents and they are happy that their kids should be in the room, then I'm absolutely fine with that. But without their wishes, grown-up children will not be allowed in that room. And grown-up children can request their parents
Sorry
to
to
have.
interrupt you, Jess, but the question I think is more about I'm like grown up kid for my parents. Can I make a will for my parents if something happens to me?
Okay, so answer is yes to that, Alok Bhaiya. So what happens in this question, if this couple, let's take an example. So we're talking about 35, 40 years old couple, and they're talking about having a will. They can leave the money to their parents in their will. Of course, we have a lot of IT consultants who've come from Wipro, Infosys, a lot of doctors, surgeons, solicitors that we look after as our clients, and they don't have families here. Just like us, it's me, my wife, and two kids here in the UK. My parents, my siblings are all back home. So our will says everything to each other and then to children. But if I want to put a proportion of my money or all the money to my parents or my siblings in India, yes, of course, you can leave anybody your estate or a proportion of your estate. It doesn't matter where they physically reside. They could be anywhere in the world and you can leave them estate. So answer is yes to that question, Alok Bhaiya. And earlier what I was answering to Naresh Bhaiya, so grown-up children can request this to their parents to have a valid will, but ultimately it's the one individual person drafting or deciding by the will where the wishes need to come from.
That's perfect. Thanks, Jess. I think you have answered the question perfectly.
No
And,
problem. Yeah, my pleasure. Anything else so far before we go further?
I think there was there was one question asked in terms of the mirror will.
Okay,
So
I can answer that. So mirror wills means if husband is saying everything from my estate on my death goes to my wife 100%, because it's inheritance tax free as well to do it that way. It is effective in most of the cases. And then everything goes to my children 50-50. Then wife could say vice versa. Everything from me goes to my husband, and if husband is not there, everything goes to my children 50-50. So that is a mirror will. And why we say mirror will is slightly different, because it's very quick. It's software driven. You are IT masters, so you both understand on this call that it's very easy to click a button and say I want my wishes to be duplicated for my wife, and wife agrees to it, and mirror wills are just opposite of each other, and it's simple. But if you've had any other expression of wishes in your mind that I want my brother to benefit, Mrs. could say I want my sister to benefit from my estate, then it's not a mirror will. It could have different beneficiaries or different proportions in there, and it's quite common. And if somebody is remarried and they want their previous marriage and previous children to benefit from estate, then that can be accommodated as well. So will is very individual. If everything is together and you're comfortable with mirroring all the wishes, then it's fine. Otherwise, have individual one-to-one discussion and do it according to your circumstances and your prerogative.
Thank you. Thank you. Yes.
No problem here. Anything else? Okay, let me just carry on. So when does one need to set up a trust? So a trust is only needed when you have some specific wishes in your mind or you want to protect. For example, if you built up a big portfolio of properties, and let's say it's a buy-to-let properties, you work really hard, you don't want your children to sell these properties after your death and straight away buy fancy cars or buying places in Florida, Bahamas, etc., or blow this money away. If you're concerned about this, or you're concerned that your children could potentially make a wrong decision about their finances, about their marriage, then by setting up a trust, you could protect that. So there is no timeline for trust. You can do it, when you are adult, but practically we see that, a trust is needed when you built up your estate or you have specific wishes that you want to be adhered to from your estate, and then a trust is meaningful. And we can accommodate anything in a trust, and you could be a trustee yourself. It means you're not giving up the right or authority or responsibility to manage. You can still manage everything yourself. You can change everything in the trust. It's not set in stone, which you can't change. There are absolute trusts, which once done, you can't change it. So I will not advise you to do anything like that at such a young age, until you're 100% certain about the future. Then you keep flexibility in your trust, so you can alter the trust document, the trust beneficiaries, as the circumstances change, like your will. So that's why if you have any specific need in your family or specific relations you want to look after or specific needs, for elders or kids, we can accommodate all that. But let's not rush into this. Let's not start paying expensive monies, for setting up these trusts when actually it's not needed. When the objective can be achieved by doing a proper will, don't go and rush into setting up these trusts. Okay? And I can see on the screen.
Jaswinder bhai, I have a question about trust.
Hello, Dilip here.
Yeah. Nice. You are giving very informative sessions. And sorry, I joined late.
Thank you.
But I was more interested on trust. So I have very specific question around it.
Sure. I'll try
What
my
I
best.
have heard, one, if I form the trust, then inheritance tax can be avoided by my child. Second
Okay.
question I have is why you are saying, what is the key specific reason why you are saying that we should not form the trust now, and you are suggesting that it can be formed later? And third question I have around the costing involved about trust. Some lump sum, not exact, but I know that you may not be able to give me exact figure, but some kind of a cost involved with trust formation.
Okay, well, that's great. Thank you very much for these questions. They are very, very valid questions, and they're all relevant to what is prevalent in the market and our families today. So let me address that one by one. And if I don't clarify anything, then Dilip Bhaiya, please stop me and we will go deeper into that. Okay?
Sure, definitely.
First question about trust and inheritance tax. You are absolutely correct on that. So some types of trust are potentially exempted from inheritance tax. Most of the people know about normal 7-year gifting rules. For example, if you gift anything to a trust which you built up and you have stayed alive for 7 years, after that, that gift is completely inheritance tax free. Okay, so that is definitely true with the gift rules to the trust. it appears on normal gifts as well. So, for example, if you're giving £100,000 to your child to buy a property and it's a gift, and if you survive 7 years, after that 7 years, HMRC will not ask them to put that 100,000 as your estate value. If you die within 7 years, then that 100,000 could potentially be added to your estate value again for inheritance tax calculation. But you're right, if a trust is set up correctly, and I'll give you one more example, which I mentioned earlier about life insurance. If you are a limited company director, shareholder, or say you're a doctor with a private clinic, which is a limited company, or you are a locum going to a hospital after NHS hours, then you could potentially buy a life insurance, which is called Relevant Life, and it is paid, the premium of that life insurance can be paid by the limited company. For the directors, for the company secretary, it could be your spouse, it could be children if they are involved in the job or business. So there are many things. If you set up that policy, any life insurance, you'd be surprised if I give you a statistic that more than 70% life insurances sold in the UK are not properly done in a trust document because financial advisors have cut corner, because it's only 5 minutes time, that's all it takes, but advisor possibly didn't have the knowledge or they cut corner and they did this. I'll give you one more scenario on this. £1 million life insurance has been written to protect the family in case of death, and that £1 million after the death goes to the family, but because of inheritance tax issue, family only inherits 600,000. They lose 400,000 because the advisor has not put that document in place correctly, or the client who's passed away did not know about it. So it's ignorance, and which is bliss, as you know. But if that policy is written in proper trust, what happens? That money, all £1 million, goes to your beneficiaries without any inheritance tax because it's ring fenced. There is no inheritance tax. And you'll be surprised to hear, but this life cover, if it's written in trust, it doesn't even need to go through probate. When somebody's death happens, you can have death certificate within a week. Once you've got the death certificate, you show that death certificate to the insurance company, the death has happened, and they will pay that £1 million without inheritance tax issue straight away, not waiting for probate, which could take 3 to 6 months. So having that life insurance in a trust, it makes sure it's inheritance tax free. Secondly, it is paid without the probate. And thirdly, it is paid to the right beneficiaries without anybody else coming into a claim situation. So you're right, if a trust is done properly, it can be very efficient against inheritance tax. And in reality, Dilip Bhaiya, we call inheritance tax a voluntary tax. It's a big, big revenue for the government. And you can understand now Rishi Sunak and the Prime Minister, they'll be working on what is the best way to increase our revenues. They've been, since February, March this year, they have been dishing money out for all grants, all the furlough schemes, etc., for businesses, individuals. Now, what is the source of revenue? There is a fiscal deficit to the economy, which has never been seen, since the Second World War. They've just managed to pay the Second World War. After 1945, Second World War finished. So when this deficit will be paid? So it is a problem in the system. But having done these things properly, and revenue can be increased, so Chancellor could increase the inheritance tax. Chancellor could reduce the nil rate band of 325,000. Chancellor is already talking about anybody who has more than one buy-to-let property, they could potentially pay higher tax. We have limited companies and we pay only 7.5% dividend tax up to £50,000. First 2,000 is free anyway. But they can increase the dividend tax just in line with the income tax, which is 20%, up to 50 grand. So tax is going to be a big issue. And we call it voluntary because you can avoid and completely mitigate inheritance tax liability by setting up a proper life insurances or by gifting that effectively. And I'll mention one more point because I'm an investment advisor. So we do AIM market investments. You must have heard about London Stock Exchange and alternative investment market, AIM market, where all the Majestic Wines, Hotel Chocolate, Brooks McDonald, etc., all these big companies are registered in the London stock market situation. So all these companies, you invest in these small companies, and only after 2 years, all that money is completely inheritance tax free. It doesn't even need to be gifted away for 7 years. So I've got clients who have got these portfolios, and you can get away from inheritance tax within 2 years. All the growth, all the investment will be inheritance tax free after 2 years, and the money is invested in your name, and you don't need to gift it to anybody, and you can still take capital and income out at any time, just like a normal ISA. So sorry, Dilip Bhaiya, you wanted to say something?
So I got about your life insurance policy part, where if I use correct form of correct details, I could avoid, I mean, not, I won't call it avoidance, I will call it that my money stays with my next generation rather than
But
it
Dilip
goes
Bhaiya,
to the government.
is okay as well. We are here to mitigate and avoid unnecessary taxes. Obviously, I am Financial Conduct Authority, regulated financial advisor. So we will not talk about any sort of tax evasion, you know. But legally and legitimately, whatever we can avoid and mitigate, we are here to give guidance about that tax planning. So it's absolutely
agree on that part, but people goes freak out when you talk about avoidance, because then you are basically going against rule or something, or you are finding a loophole in the rule.
Absolutely.
But let's not get into that.
Sure.
So my second question is about property.
Yeah. So
is there any way apart from trust I can avoid inheritance? Not avoid, I mean, I can save my inheritance tax.
Yep. So let me answer that. So we have a lot of family situations, a lot of clients with property portfolios. So let's look at that. If you have a buy-to-let property owned by yourself and your wife, and you're getting a rental income of £1,500 a month, and your mortgage on that property is £500 a month. If you go 5 years ago, you were only paying tax on £1,000 in that example. So you will take off your mortgage payment, and then you will pay tax only on the profit you make on a monthly basis. But now that is gone. As you know, it phased out in 4 years. And now you pay tax on all £1,500. If you're a high rate taxpayer earning more than 50,000, you're straight away paying 40% tax on that. But if this property was in a limited company, then you can still offset the mortgage and trust payment. And if you're earning enough from your job, from your business, then all this income can stay in that limited company for further buying other properties. So you don't need to draw this as further dividend and pay higher rate or additional rate tax. So there are situations where you can do that. And if you have, say, 3-4 properties or more, except your main residence, because what the problem comes, if you bought a property for 200,000, buy to let, as you know, on the main residence where you live, there is no capital gains tax. But if it's a buy to let, you bought it for 200,000 a few years ago, now it's worth 500,000. If you try to put that in a limited company now, you have made 300,000 capital gains. So you will pay capital gains tax on that. The company will also pay stamp duty to buy that. So there are issues, but not a lot of people know about incorporation relief. So if you have more than 4 properties, potentially you could put all those properties into a limited company. Firstly, we form a partnership, and then we put them into a limited company, which is absolutely agreed by HMRC. And it's not very aggressive tax planning with HMRC, which you were absolutely correct when you said avoidance schemes. HMRC doesn't like aggressive tax planning, but this is absolutely fine they have been agreeing and doing it for many, many years. So if you have more than 4 buy-to-let properties, jointly, singly, or with children's name, however it's owned, you can put them all in a partnership, and then eventually in a limited company. It can take up to 3 years, but potentially you won't need to pay any capital gains tax or any stamp duty to do that. And in future, your children could become shareholders of that limited company, and they could get that without paying inheritance tax. So there are many ways where you can avoid inheritance tax completely, or try to mitigate a proportion of it by sensible and forward planning. That's all it takes, that you know the rules, but you need to execute and implement. Problem happens where people leave it too late and think, oh, I'm not going to die, now, I'll think about this after 70, 80. And that's where, means I won't like if my client dies with an inheritance tax liability, and I've been looking after these clients for last 15, 20 years, because I haven't done my job properly. And that's why, otherwise family could question that, Jazz, you've been looking after my parents for last 15 years. Why do I have this inheritance tax bill after their death? And that's a very valid question. So if we put that place, then you won't need to worry about it. And you have businesses which you can pass on to your children as per business property relief, which is exempted from inheritance tax. So there are many ways you can completely eliminate inheritance tax liability. Does that answer your question about properties, Dilip Bhaiya? Okay, so let me just pick up the questions. I can't see Dilip Bhaiya any longer here. So that question about trust now or later, yes, there is no age for trust. So explain me what your assets are. Convince me, why do you want to do a trust, and what do you want to achieve from that trust? And then I can say you're doing the right thing. I don't want anybody to sell you the trust because it's going to earn them £3,000, £5,000, and you actually didn't need it. I want you to set up a trust. When it's absolutely essential, you are given proper advice about it, and you know the pros and cons, why you've done it, and what you're losing by setting up this trust. Whether it's an absolute trust, which you can't change, it's irrevocable. Whether it's a flexible trust where you can change absolutely fine at any time. Whether it's a vulnerable person's trust. Whether it's a trust protecting your spouse, so children couldn't send their parents out of their home, So to protect these scenarios, a trust is very important. If you're concerned about creditors with your spouse, with children, if you're concerned about your children's future partners, then setting up a trust makes perfect sense. And I will cover the third part. Dilip Bhaiya asked me about the costing. So it varies. You're right, it's very difficult without looking at personal scenario, but we are highly competitive. But the rate in the market for setting up a basic trust, say a protective property trust, it's not more than £500 to £1,000. It is set up within the will. A will trust, we can do it only for £150 within the will. So that's fine. We would do wills, which every will is checked and approved by the compliance, not a sample of it. Most of the companies you will come across in the market, they will say, we have indemnity insurance for it. So if anything goes wrong, you're covered. But why get to those situations? So in our case, every will is checked and approved by the our compliance team before we can come and get the will signed with you. And it's only £150 for a will. And there are wills, WH Smith Pack, we talked about £25. A lot of companies do it for £99. Some banks do it for free. But be careful, they will put themselves as your executor. And when you die, they want to charge 4% or 3% of the estate value. On £1 million estate, 4% is £40,000 because you didn't know. And obviously you've died. So your kids don't know what parents agreed, in that will. So just be sensible and keep your due diligence and your sensible hat on, so you know what you're signing and why somebody is doing a will for cheaper. Are they making themselves as executor of your will, or they're just giving you advice and it is not protected? Because wills are still non-regulated in the UK. So just be careful. Anybody can do a will for you. Just be careful about their qualifications. Are they fully qualified solicitors or financial advisors? Have they got know-how and practical experience in the market? What goes wrong? Okay. So costing varies, but a simple trust could be 500 to 995. If you're looking at care home trust, where you don't need to pay care home fees, where you can save potentially 5 grand a month, for yourself or your parents, that trust could cost only £2,000 to set up, and it protects £5,000 per month, for a longer time, when you are taking that care. Because as you know, within the UK, up over £23,500, if you have that in your investments or your bank accounts, then council will not pay the care bill. So anything below 23,500, they will take the bill for your care, but then you don't get a choice of care, which care home you want to go in. And if you have all your assets protected in a trust, then council cannot push you to sell those assets for your spouse or yourself to pay for that, because your kids are the beneficiary and they are the future owners of this. So that is covered. I hope I've answered those 3 questions from Dilip Bhaiya, but please come back if I haven't clarified it enough.
You did well, and I think rest all require consultation anyway. So it was very good, and I'm sure all audience will be benefited out of it.
Thank you so much, Dilip Bhaiya. But you can pick it up on a private call. No problem at all, Bhaiya. Absolutely fine.
We'll call you once I am back in UK. We'll give you a call.
No problem. Keep safe anyway. Any other questions? So, Alok Bhaiya, could we go to the next slide? So this is just what we have achieved so far and our contact details coming. So we are financial consultants. London Financial Consultants is a limited company. I'm director of London Financial Consultant, which is part of a network called New Leaf Distribution in Essex. So that covers indemnity insurance and guarantee of advice. So any advice we provide you is covered and it's guaranteed. That's my background, and we've been blessed, to be this position. And we have had many awards in financial markets. So you can see that on the screen, we're blowing our own trumpet. And Alok Bhaiya, could we go to the last slide, which is just contact details. So anybody who wants to get in touch, we've got our email address, my mobile numbers, and also the landline. I live in Hertfordshire, Letchworth Garden City. Our main offices are Potters Bar, which is next to North London, Barnet. And we've got office for administration in Hitchin as well in Hertfordshire. And we've got a compliance office in Southend-on-Sea, Essex. But with technology, it's all global now. So it doesn't matter where you're based. Don't hesitate to pick up the phone or drop us an email with your circumstances, and we will get back to you very, very quickly about this. And Naresh Bhaiya, anything else you want me to clarify?
No, I think thank you very much, Jess, for your time. It was very informative session in terms of knowing. In fact, when I started my journey in terms of knowing about the trust, it was totally blank. And once I had attended your session, it was just, you have cleared many of the doubts. And I'm very glad that you have given us your very precious time.
Yeah, you are ever so kind. Thank you so much for having us, Naresh Bhaiya. Anytime. So this was particularly for wills and power of attorney. And I really like the concept that we're trying to educate our own families what they need, in these eventualities. So let's keep it to that. Let's avoid sales pitch from our side that, we're trying to sell something. But please don't hesitate to bring us for anything. If anybody wants to know anything about pensions, investments, God has been very kind. We've been the top financial advisors nationally. So we don't need to come and try to pitch for financial gain and monetary gain. You've known us, Naresh Bhaiya, for a longer time to understand our personalities. And that's why, please don't hesitate. Anytime we can do any education piece for our families, it will be absolutely a pleasure, Bhaiya. Absolutely fine.
Same here. Thank you very much. Yeah.
That's so lovely. Thank you very much, Jas bhai. Thank you.
No, thank you so much for having us once again. Have a wonderful time and have a great Christmas. And let's hope 2021 is much, much better and it's a healthy one.
Yeah. Thank you.
Definitely.
Definitely. Thank you
Thank
so
you.
much.
Thank you.
Have a
Thank you.
wonderful time. God bless you. Bye.